Senator Sheldon Whitehouse just asked Treasury Secretary Scott Bessent a simple question. Has there ever been any precedent in Treasury or IRS history for an agreement not to audit, investigate, or pursue tax claims against a president's family or businesses? Bessent could not name one, because there is none.
Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
The background is extraordinary. A contractor leaked 400,000 tax returns, including President Trump's. Whitehouse asked what contribution is being sought from the contractor. Bessent said they removed the contractor's contracts. No money, nothing.
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
Then Whitehouse asked the key question. Was there any consideration offered or paid in return for the settlement that gave Trump and his family immunity from audits? Bessent said he could not answer because of ongoing litigation. Whitehouse pointed out that litigation does not bar a witness from answering a simple fact question. Was there or was there not consideration? Bessent would not answer.
If there was any consideration offered or paid in return for that settlement, it's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
Whitehouse, a lawyer for decades, called this game of dodgeball completely inappropriate. He asked if anyone analyzed whether Trump actually suffered harm from the leak. Every president since Nixon released their taxes voluntarily. Bessent would not answer. What goes around, comes around. Senator Whitehouse is watching. Let's watch.
Thank you, Senator Whitehouse.
Thanks very much, Secretary. Welcome. Have you identified any precedent in Treasury or IRS history for the agreement not to audit, investigate, or pursue any tax claims against the Trump family or businesses?
I can't identify any precedent where 400,000 tax returns, including the people you just mentioned, and all of their employees were leaked in a violation of one of the most sacred duties of the IRS.
So let me cut to that then.
Senator.
The leak was by a contractor. Can you tell me what contribution is being sought by Treasury or by the IRS for the harm done by the contractor? To a certain extent, your organization and the IRS are the victim of the contractor's malfeasance or negligence. What is being pursued by way of contribution by that contractor?
Well, the ranking member chastised me for cutting the contractor's contracts off, and we have removed their contracts, their ability to do business with Treasury and the IRS.
But there is no contribution into this particular case.
Again, Senator, you weren't here earlier, but I'm unable to discuss most of this because of ongoing litigation.
Yeah, I know everybody likes to say that, but the constitutional...
We like to follow the law, Senator.
And the law is that the Congress has constitutional oversight functions that do not disappear simply because there is litigation, however convenient it may be, by way of providing answers. So we have no precedent for it. No contribution is being sought from the contractor at fault. Was there any consideration to the government in return for the benefits of no audit, no investigation, no challenge or pursuit of refunds or other penalties?
Again, Senator, I'm unable to comment because of litigation. Treasury is represented by the Department of Justice In all matters, they act as our attorneys, so I would suggest that you direct your questions to Acting Attorney General Blanche.
Yeah, well, I've had a lot of times people who are before us invite me to ask my questions of somebody who's not before us, but you're the one who is before us, and I think you ought to know if there was any consideration offered or paid in return for that settlement. It's a very simple fact question. Was there or was there not consideration?
Again, there's ongoing litigation, and I suggest that you speak with the Treasury attorneys.
If this kind of behavior is okay with the chairman, I'll just pursue other questions. But, you know, what goes around comes around in terms of dodging questions.
I believe it's very clear that witnesses of any kind cannot discuss ongoing litigation.
They can certainly discuss a fact that they are aware of. The fact that there is some litigation out there doesn't mean that a witness can't say, yeah, there was no consideration, or yes, there was consideration. Was there a defense analysis memo? It's referenced in the judge's decision in Florida. Was there a defense analysis memo prepared by the IRS? And more specifically, did you see it?
Again, I'm not going to be able to comment on these matters.
Mr. Chairman, this just makes no sense at all. I've been a lawyer all my life. I have some idea of what is protected when you have a ongoing bit of litigation. Whether this individual has seen an official memo from within his own department is a very simple question to answer. And I think it's completely inappropriate to have this game of dodgem be pursued without any consequences. Well, last of all, here's another question. Was there any analysis of what harm befell President Trump from having his taxes released when every president since Nixon released their taxes and he had promised to? Did anybody analyze whether there was actually any harm at all to him in those circumstances?
So there was a crime. President's rights under 6103 of the IRS code was violated, and equally as important, 400,000 taxpayers had that right violated, including every employee of the Trump administration, the housekeepers at Doral, the greenskeepers, and the cashiers.
And you're welcome to pursue all of that, but it doesn't answer the question of whether the president actually suffered harm. And you're not answering that question either.
Senator Cortez Masto.
This hearing is a masterclass in how to watch a witness use ongoing litigation as a shield against legitimate congressional oversight. Senator Sheldon Whitehouse came prepared with specific questions, legal expertise, and the patience to keep asking even as Bessent refused to answer. The result is a hearing that exposes the administration's stonewalling for what it is. Whitehouse began with a question about precedent. Has the Treasury or IRS ever before agreed not to audit, investigate, or pursue tax claims against a president's family or businesses? Bessent could not name any. Instead, he pivoted to the leak. 400,000 tax returns were leaked. That is terrible. But that is not the question. The question is about the settlement that followed. The leak was by a contractor. The contractor was the wrongdoer. The IRS and Treasury are the victims. Whitehouse asked what contribution is being sought from the contractor. Bessent said they removed the contractor's contracts. No contribution, no money, nothing. The contractor who caused the leak faces no financial penalty. That is a choice. Then Whitehouse asked the key question. Was there any consideration offered or paid in return for the settlement that gave Trump and his family immunity from audits? Consideration is a basic concept in contract law. It means something of value exchanged between parties. If the government gave Trump something, immunity from audits, did Trump give something back? Did he drop a lawsuit? Did he agree not to sue? Did he pay money? Bessent would not answer. He said he could not comment because of ongoing litigation. Whitehouse pointed out that litigation does not bar a witness from answering a simple fact question. Was there or was there not consideration? That is a yes or no question. Bessent still would not answer. Whitehouse then asked if there was a defense analysis memo prepared by the IRS, referenced in a judge's decision in Florida. Did Bessent see it? Again, he would not answer. Whitehouse, a lawyer for decades, said this makes no sense. He knows what is protected during litigation. He knows that asking whether someone has seen an internal memo is not protected. Bessent is hiding behind a legal excuse that does not apply. Whitehouse then asked the most devastating question. Was there any analysis of what harm actually befell President Trump from having his taxes released? Every president since Nixon has released their taxes voluntarily. Trump promised to release his taxes. He did not. The leak was wrong. But did it cause him actual harm? Bessent would not answer. He talked about the crime. He talked about the 400,000 taxpayers whose rights were violated. He did not answer whether Trump suffered harm, because the answer is probably no. Trump's taxes were leaked. Nothing happened. No prosecution. No political consequence. No harm. So why did he get immunity from all future audits? That is the question Bessent will not answer. Whitehouse's closing line was a warning. What goes around comes around in terms of dodging questions. He is not threatening Bessent personally. He is making a point about the institution. If the administration can dodge questions today, a future administration can dodge questions tomorrow. The precedent cuts both ways. Whitehouse is a former prosecutor. He knows that oversight only works if witnesses answer. Bessent is not answering. The underlying issue here is not the leak. The leak was a crime. The contractor should be punished. But the settlement that followed is the real story. The administration used the leak as a pretext to give Trump and his family blanket immunity from tax audits. No precedent, no consideration, no analysis of actual harm, just a deal. And when asked about it, the Treasury Secretary hides behind ongoing litigation. That is not a defense. That is a cover-up. Whitehouse did not get the answers he wanted, but he did something important. He created a record. He showed that Bessent could not name a single precedent. He showed that no contribution was sought from the contractor. He showed that Bessent refused to answer whether there was consideration. He showed that Bessent refused to say whether he saw the defense analysis memo. He showed that Bessent refused to say whether Trump suffered any actual harm. That is not a successful hearing, but it is a necessary one, because sometimes the only thing you can do is show that the witness is hiding. Whitehouse showed it.